An investment in knowledge pays the best interest. Greatly said by Frankfurt. And a very good evening to everyone present here, distinguished dignitaries, respected faculty members, dear students, and our esteemed guest for the day. It is my pleasure to welcome you all to the day two of the International Speaker Series titled by Global Jurist Connect, a scholarly convergence, hosted by the Faculty of Law at GLS University. We are excited to continue this series, which serve as a platform for global academic engagement, fostering collaborations and promoting insightful discussion between scholars and students across borders. So to begin with today's program and a session, we will start with a welcome address. And it is my honor to invite Dr. Mayuri Pandya ma'am, Dean of Faculty of Law, GLS University, a distinguished academician and an expert member of Environment Appellate Authority, Government of Gujarat, and also who contributes to the Ministry of Government, Forest and Climate Change's Appraisal Committee at the national level. I request you, ma'am, to please address welcomes one. It's up to you, ma'am.
Thank you. Thank you, Ria. A very warm welcome to everyone joining today on this virtual platform. Dr. Katia Rener and all the budding lawyers and all my colleagues who have joined today. I welcome all of you. This is the day 2 of the Global Jurist Connect International Speaker Series. And this series embodies our vision of fostering rigorous academic dialogue, global legal engagement, and meaningful exchange of ideas across the jurisdictions and the disciplines. This series, scheduled from 16th to 20th February, it has been very carefully curated to address some of the most pressing legal challenges of our time. We begin this scholarly journey yesterday with Dr. Simon Behram, Reader, School of Law, University of Warwick, United Kingdom, who engaged us in a thought-provoking discussion on climate change and forced migration, a challenge to the legal framework. Today, we shift the focus from humanitarian and environmental vulnerabilities to the legal and contractual dimensions of the global energy transition. We are delighted to welcome Dr. Katia, who is associate at Clyde and Company's Global Arbitration Group, Germany. She is going to discuss the Renewables Arbitration vis-a-vis the German contract law. This session will focus on the intersection of renewable energy projects, commercial certainty, and dispute resolution within a leading European legal framework. Dear all my students, this series is designed to expose you to diverse legal systems, contemporary global challenges, and to enrich your academic and professional perspectives. Once again, I warmly welcome all the participants, Dr. Katia Rener, and wish all of you a meaningful, insightful, and enriching session today. Thank you, and over to Dr. Rener.
Well, thank you very much for the kind introduction and for inviting me to speak to you today. I'm delighted to share insights from my practice and explore with you how arbitration in renewable energy projects in Germany actually works on the ground and why German contract law is the key to understanding outcomes in this sector. I have prepared a slide deck. If we could start sharing this. I will be sharing it, You can share it via email with all participants afterwards. Just kind of as a sort of disclaimer, I've kept it very, very brief and kind of to the core principles without citing any actual contractual provisions, just to kind of give you an idea of an overview of how German contract law works in this sector, which you may be able to revisit, but without overwhelming you with too much information. Because, I mean, the goal sort of here is kind of a simple claim. So if you don't understand the contract law foundations, an arbitration case in a renewable energy project will feel unpredictable. But if you do understand them, disputes become much more manageable. So why is this important now? Germany is a global leader in renewable energy, particularly in wind and solar. And with the energy transition, the volume and complexity of projects have increased dramatically. Foreign investors, including Indian companies and funds, are active on the German renewable markets. Projects are usually long-term, capital-intensive undertakings. And this is one of the reasons why disputes in this sector are rarely litigated in national courts. So they're arbitrated, seated in Germany, governed by German law, conducted in English, and administered by institutions like the DIS or the ICC. But this is, well, the challenge from a global perspective. German contract law works very differently from, let's say, Indian contract law. So if you come from a common law background, your instincts are shaped by precedent, by familiar doctrines like consideration. In Germany, we start somewhere else entirely, which is the civil code, the Bürgerliche Gesetzbuch BGB. So my goal today is, as I kind of mentioned at the outset, not to turn you into experts into German law in just 50 minutes, but to make you comfortable with how contracts are formed in Germany, how they're interpreted, performed, and terminated, what typical disputes in renewables may arise and why arbitration is preferred, and just to highlight a few key differences to Indian law that matter for drafting and strategy, and just to make you more comfortable in general when confronted with a foreign legal system. So why are renewable energy contracts in Germany so complex? Well, usually these types of contracts run for 20, 25 years. They're high value, they're technically complex. They typically involve regulated entities, public bodies, multiple actors, which increase complexity and therefore the likelihood of disputes. Typical contracts may range from power purchase agreements, grid connection agreements, EPC contracts, that is engineering, procurement, and construction, and OMM agreements, that is operation and maintenance, all in one singular project, which, of course, does not decrease the complexity. But I mean, here's sort of my hypothesis. If you understand how contracts in Germany work and how German lawyers think, this complexity will not shock you anymore. So let me start with a very quick example just to set the tone. So hypothetical, two companies agree on a solar panel supply contract. No consideration, no written document yet. Is this a binding contract? If you're thinking in Indian terms, your mind will inevitably jump to consideration and formalities. In German law, the analysis is simpler. Offer plus acceptance equals contract. Consent is what matters. And most contracts are actually valid without any specific form, unless the law mandates writing or notarization for certain contract types. So this illustrates the German mindset. If we could please go to the next slide, please. So really the civil law thinking. German lawyers begin with the German Civil Code. It's a highly codified and systematic text. So German lawyers do not ask, what do cases say? What are the precedents? We ask, which section of the codes apply? So precedent does matter, of course, but the primary structure comes purely from statutory law. So maybe think of it more as legal mathematics. You start with the definitions and the theorems, and then you apply them to the facts of any specific case. So just briefly, let's get into the German Civil Code scaffolding you will need. So where in the German Civil Code does contract law live? So the German Civil Code consists of 5 parts. So first is the general part. Those are common rules relating to capacity, representation, limitation, etc., i.e. rules that apply to any contract type regardless. Second, you have the law of obligations. So this deals with contract formation, performance, breach, damages, termination, and also special contract types such as purchase, services, construction agreements, etc. And then come property, family, and inheritance law, which is really not relevant for this here. So the key consequences for the practice of law in Germany is you have a certain degree of predictability. So because the system is so codified, you can structure your analysis step by step according to the wording of the provision that is applicable at hand. You also have uniform concept. So a doctrine like good faith applies across the board, and you don't necessarily have to reinvent it or to modify it per contract type. Also, you already have a certain amount of risk allocation per the codification. So freedom of contract is a robust concept also in German law, but it is not absolute. So it is framed by certain mandatory rules and doctrines that, again, are applicable through all types of contracts, and also give a certain level of stability and legal certainty to contractual relationship. So moving on to some of the most important details for contract law that are important for you to understand in a cross-border sector. And if we could go to the next slide, please. So first, let's walk through formation of a contract. So I've already explained it in the beginning. It's pretty simple in Germany. So offer and acceptance equals contract. What does this mean? A proposal that is sufficiently definite and signals the intention to be bound is considered an offer. Acceptance must clearly mirror such offer. If any term of the offer is changed, you have made a counter offer. So this can actually happen quite often in the negotiation of project contracts, specifically when relating to engineering, procurement, and construction that are very high level, very complex. So in practice, you will have PDFs volleying back and forth on a daily basis, red lines accumulating, and legally, you're often trading offers and counter offers until the parties finally reach an agreement or clearly acknowledge acceptance of certain terms. So even if this may seem very lengthy and exhausting in practice, in the end, you will ideally have a solid contract that both contractual parties have agreed to. However, it is important to note that in Germany, consideration is not required. So to give you an example, a turbine supplier emails the investor and says, we will extend your construction deadline by 2 months. And the investor agrees. And in Germany, that would be considered consent. So the modification is binding and no additional consideration is required. So in very simple terms, when it comes to contract formation in Germany, you can focus on the clarity of consent and any form requirements alone. So when do we have form requirements in Germany? So if you remember my initial example, I implied that the oral agreement regarding a wind turbine supply contract might be valid. And that would usually be the case. So oral contracts are valid in Germany, although they're very uncommon, if not to say non-existent in renewable energy projects. And this is because most contracts are form-free. But the German Civil Code imposes form requirements for certain transactions. The most common in renewable energy projects are guarantees, which require written form, and any real estate transfers, which require notarization. So the initial example of the wind turbine contract would still be valid, provided that there is a clear offer and acceptance. However, to give you another example, if a parent company were to give an oral performance guarantee for its subsidiary, this would much certainly be void for lack of form. So in practice, this is something you will always need to check. But the good thing is that this is always written in the specific provisions in the civil code relating to specific contracts. So just a quick word on Battle of the Forms. So in complex projects, especially when it comes to the supply of certain components, each party may want to attach its own standard terms, for instance, its general conditions of sale. So if both sets are declared applicable and conflict with one another, this is something that needs to be resolved. So which terms actually govern the agreement? So ideally, you catch this during the drafting process and provide a clear order of precedence and confirm that in the signed contract, or just agree on one set. And the reason why this is important in a cross-border German context is that German law does not recognize a common law last shot rule. So if there is any dispute on such an issue, tribunals will examine the standard terms independently and determine which ones are relevant based on objective standards, and often just replace them with statutory rules. But as I said, in practice, this can be easily prevented by drafting the contract to avoid any battle of forms. Still, it's something that is very relevant, let's say, in the negotiation process in such projects, because parties will understandably often try and keep negotiations informal in an email exchange to retain maximum flexibility. And while this is completely understandable, at a stage where the contractual terms have not been clearly defined yet, the downside, of course, is legal uncertainty about whether and which terms are ultimately accepted. So now let's look more into the freedom of contract and the centrality of risk allocation. If you could please go to the next slide. So German law strongly protects freedom of contract in general. And this is also a cornerstone of drafting contracts in large-scale infrastructure projects in the renewables energy sector. So what does that mean specifically? As I mentioned before, these types of projects often involve regulated entities, a lot of public bodies, different types of regulations to observe. And so if the contract allocates a regulatory risk to an investor, any later change of law could be relating to grid fees or feed-in tariffs, etc., might not automatically trigger any contractual relief. Or similarly, if a contractor in a construction project accepts a site risk, any unexpected soil condition or permitting hurdles may remain their risk if there is no clause shifting it back or allocating it between the contractual partners. So if it comes to a dispute, tribunals in Germany will routinely start with asking, how did the parties allocate this risk? So if the risk was foreseeable and allocated, there is no automatic judicial rebalancing. So this is why drafting will typically include questions of hardship, force majeure, change in law, and indexation clauses, really depending on the project's financing model, or also the general location of a project, to account really for all types of circumstances that may arise and inhibit the smooth completion of a project. But you may ask, what happens if you cannot foresee every possible risk in the contract? What if the circumstances change so dramatically that it would be an undue burden for one of the parties to adhere to the contract as is? To give you an example, so suppose a dramatic, unforeseen legislative change invalidates a key subsidy without a transitional regime, and the contract is silent on such a risk. The project economics may collapse. Or similarly, and also not uncommon, an exceptional spike in commodity prices or a war-driven supply chain breakdown may also significantly affect the completion of a project. And German law actually has a solution that actually comes into play quite regularly in renewable energy projects during regulatory or economic transition. And this is called contract adjustment if the basis of the transaction has been disrupted. So this is actually foreseen in the German Civil Code. And this concept follows a three-step logic: a fundamental change of circumstances after contract formation beyond normal market swings, a change that was not allocated as a risk to the disadvantaged party, and, well, holding the party to the original deal would be intolerably onerous. And the idea behind this is that the parties would not have contracted at all or on significantly different terms had they foreseen this change. And if it would have been unreasonable to hold the parties to the unmodified contract. So if these criteria apply, the disadvantaged party may demand adjustment. And if adjustment is impossible or unreasonable, the contract may even be terminated. However, it has to be noted that even though this option exists in the German Civil Code, German courts and arbitral tribunals apply it extremely cautiously and only as a very last resort in very few cases. But again, I mean, in the past years, with COVID-19 pandemic, with the war in Ukraine, the application has become much more common. So in the sometimes volatile and not always predictable renewable sector, this can actually happen not infrequently, let's say. Now let's come to a very important principle of German law that you may really associate with German law if you already have some experience in this area, and that is good faith. So what is this? So under this principles, parties are required to perform and interpret contracts in accordance with good faith, taking into account fair dealing. Again, this is also codified in the German Civil Code. So this is not purely decorative. It actively shapes duties and outcomes. So what can it actually do in practice? So the most common application is where it creates actual duties to cooperate, to inform, or to avoid any abusive enforcement of contractual terms. And also to maybe restrain a party from taking opportunistic advantages of a contractual technicality that would defeat the contractual purpose and jeopardize the entire project outcome. So to give you an example, a grid operator delays grid access and then seeks to enforce delay liquidated damages against the investor. So an arbitral tribunal or court may find that a strict reliance on the contractual penalty is contrary to good faith, particularly if the operator itself contributed to the delay. Or similarly, in an EPC contract, for instance, if a contractor discovers a design defect but remains silent on it while milestones accrue, this can actually shift the liability towards him, because good faith can also mean a duty to warn and to cooperate. So in practice, while this is definitely a valid consideration that appears very often in disputes, it still may be notoriously difficult to prove. And the burden will lie on the party invoking the principle. And I mean, any proof would also entail, let's say, market practices, et cetera, to really look at the whole picture here. But still, in fast-paced and large-scale, high-volume infrastructure projects, this may be a decisive factor that can ultimately win a very close case. And so in this respect, it may also possess a more systemic strength and pervasiveness compared to the common law principle of implied duties. So, I mean, just something to remember in the cross-border context. So even if there is no duty of cooperation drafted into the contract itself, if German law applies, it may apply through statutory law and principles in case of a dispute. So if we could move on to the next slide, please, and contract interpretation. So German arbitral tribunals and courts usually interpret contracts very objectively. And the question they will ask is, what would a reasonable commercial party in the position of the parties understand at the time of the conclusion of the contract? The key features are text first, but not text alone. So context and commercial purpose do matter. But any secret subjective intent that is only revealed later will not be taken into account. And so if any ambiguities cannot be resolved by looking at the text alone, they will be resolved by examining structure, risk allocation, market practice, and purpose of the contract. So to give you an example, if a power purchase agreement uses ambiguous language around curtailment of electricity, which actually happens quite often, just the electricity, let's say, of a solar park is reduced, a German tribunal will consider grid context, regulatory framework, and also the specific economic model of the operator in question to identify the commercially sensible meaning in this specific agreement. However, although you do have kind of like the legal certainty and kind of fallback of this strictly objective interpretation in drafting contracts in the renewable energy sector, it is always sensible to include definition of contractual terms as well as purpose recitals that describe the project economics. Because in hard cases, they can guide tribunals towards the intended interpretation. So if we could move on to the next slide, please. So let's get into more sort of concrete examples of breach of contract and damages. So actually the things we actually argue about in courts or before our tribunals. So under German law, in general, any non-performance is a breach of contract. And fault is usually presumed, including negligence. So usually the debtor must prove that they were not at fault. However, and that is quite common in contracts in the renewable energy sector, parties can define standards of care or caps subject to mandatory limits or economic power. So this is actually quite common to kind of look at the different, different actors like in an infrastructure project to see how much economic power do they have, how much control do they actually have, and do we need to allocate standards of care differently. But I mean, even if you have to fall back on statutory provisions, one thing you need to note about damages in German law is that they are compensatory only. So German law does not award punitive damages. Any such clause would be invalid under German law, because the goal of compensatory damages in Germany is to place the injured party in the position they would have been and had the contract be properly performed. So that means that, for instance, lost profits can be recoverable where sufficiently substantiated and causally linked, of course, but any contractual penalties that go beyond this are invalid. It is slightly different with liquidated damages. So in large-scale infrastructure projects, because they are very time sensitive, that you have delay liquidated damages. So these are in principle enforceable in Germany. However, a court will look at them closely and may reduce any grossly excessive penalty to a reasonable amount. So what is a reasonable amount? Well, any amount that is calibrated to a realistic delay cost curve, and where the calculation rationale has been sufficiently documented in the contract. So what you see often, especially in EPC contracts, is that you will have a table of project milestones and certain completion dates. And if they are not met, the completion dates, you will have certain delay liquidated damages connected to them directly. So something like that is enforceable in Germany, but yeah, I mean, anything that would be purely a punitive intent would not be enforceable in Germany. So yeah, I mean, delay liquidated damages can be kind of unfortunate in practice in the case of vicarious agents. So because often a contractor, let's say, that's been contracted to construct an offshore wind park, will usually use a large number of subcontracts to perform certain parts of the project. And if a subcontractor's failure delays actual commissioning, the main contractor remains on the hook vis-a-vis the employer unless the contract reallocates the risk. So this is also something to kind of keep in mind when drafting the contract to avoid any undue burden. If we can go to the next slide, please. So a quick note on limitation periods in Germany. So the general limitation period is 3 years, ending at the end of the year in which the claim arose and the creditor had or should have had knowledge of the facts. So this is something that is very specific to German law. So even if a claim under German law were to arise as of today, based on these criteria, the limitation period would not end exactly 3 years from now, i.e. on 17th of February, 2029, but on December 31st, 2029. So this is a rather peculiar feature of German law, also colloquially referred to as the New Year's Eve limitation. So what does this mean in practice? Well, any lawyer working in Germany means, that the end of the year is usually particularly busy because claims that are about to expire must be asserted in court or in front of arbitral tribunals. So it's actually happened to me more than once that I had to work on New Year's Eve because a claim needed to be filed before the end of the year. So let's move to a more encouraging topic, and that is termination. So termination rights in the German Civil Code are very structured and narrow. So even if termination rights are regulated in detail in long-term agreements, such as power purchase agreements or EPCs, you will typically see the same principles applied. So in order to terminate a contract, you will need a material breach plus cure opportunities. What does that mean? So this means that even if you register any breach that would be grounds for termination, you must award the contractual partner the opportunity to first remedy it. So there is no termination for convenience. And this is something, that can be really risky, especially if you have parties to a contract or clients that are unfamiliar with this concept, because premature termination can be very risky. Because a wrongful termination can itself constitute a breach of contract, but more importantly, if you remedy a breach without first granting your contractual partner the opportunity to cure the breach itself, the costs incurred, for remedying the breach may not be recoverable. So the conditions for termination have to be considered really carefully during the drafting process, especially in light of the financial consequences, so that the exit math is really kind of obvious to a certain extent, at least in advance. So if we can go to the next slide. So just a very brief word on general terms and condition in Germany. So you may have heard of this before, and it is definitely something that is considered a very gross disadvantage of German law due to its strict application. So what is it? So essentially, it's a robust system to control unfair standard contractual terms. What is a standard term? So this is any pre-formulated contractual term intended for multiple uses imposed by one party. So for instance, the conditions for sale. why is it so strict, even in Germany, even in a B2B context? Well, because it stems from consumer protection law, where it actually makes sense. But in a B2B context, it can actually cause some disruption. So let me quickly walk you through this. So when determining if a standard term is unfair under German law, a multi-layered system is applied that asks first, were the terms properly incorporated? So any surprising or unexpected term may not become part of the contract. Second, who introduced or drafted the term? So any ambiguities are interpreted against the party that provided the standard terms. And third, is there any unreasonable disadvantage to the other party? And if so, they're considered to be invalid. So in general, I mean, it sounds reasonable, but it can become really annoying in practice. Because you will inevitably have discussions, be it in the submissions or in the oral hearings before courts, about whether or not certain contractual terms are invalid. So typical pitfalls may be broad liability exclusions, that also cover gross negligence, injury to life, body health, something like that is considered invalid under German law. Shortened limitation periods for defects, so going beyond these 3 years I just explained, so that effectively deprive the counterparty of claiming any meaningful remedy, or unilateral changes to termination rights without balancing any safeguards. Again, this is something that may be mitigated during the drafting process. So, just as a general rule, aim for genuine documented negotiations. So really line by line discussion to prove that the contract has actually been negotiated as opposed to standard terms being imposed, using clear, transparent language, and also aligning all terms with statutory principles and not to overreach. But however, this is something, or actually one of my favorite concepts that illustrates the advantages of arbitration. Because if you combine, let's say, the choice of German law with an arbitration agreement in a contract, a partial choice of law may be made. How does this work? So the reason for this is that the German Arbitration Act, when speaking about the law applicable to the arbitration, refers to rules of law instead of simply law or legal system. So it's similar to the definition of the Unionsvertrag model law. And this is interpreted to mean that a partial choice of law may be made, for example, German law excluding the provisions on general terms and conditions. So this test for unfair standard terms, which you're now seeing on the screen, this may be excluded in the contract by a partial choice of law. And so what does that mean in practice? So it means that if you have such a clause in your contract, any contractual terms cannot be put through this test and may thus not be invalidated on any of such grounds. And that is something that I personally always recommend to my clients, just to avoid any unnecessary disputes in future, and to really keep the legal discussions into determining whether there has been a breach of contracts, which type of damages apply, and not whether a specific contractual term was valid or not. So let's dive a bit deeper into why arbitration is preferred for renewable energy disputes. So if you could go to the next slide, please. So why not courts? So German courts in general are quite efficient, but renewable energy disputes are often very technical, international, involving foreign investors who prefer a neutral decision maker and, more importantly, complete confidentiality. Germany is a very pro-arbitration jurisdiction with a modern statutory framework. Many cases run under the IS or ICC rules, seated in Germany, conducted in English, governed by German substantive law, as I just mentioned, preferably excluding the provisions dealing with German general terms and conditions. And also enforcement of arbitral awards benefits from Germany being a signatory to the New York Convention. So in Germany, you generally have very limited court intervention, respect for party autonomy, setting aside of awards is very exceptional, and enforcement is very arbitration friendly. Is this an advantage over arbitration in India? I would say historically, maybe, because courts in India have been historically more interventionist, but significantly reformed in recent years. So public policy objections remain more prominent than, for example, in Germany, but the trend is towards greater efficiency and predictability, especially in international commercial arbitration. And I think personally that's a great achievement and very encouraging for future collaborations. Some like really brief practice tips on how to draft arbitration agreements. Stick to the model arbitration agreements of the rules you actually choose, because the thing is, the thing with arbitration is it really, or its purpose is really to maximize party autonomy. So anything the parties choose to do, or any way they choose to design their proceedings, will be given precedence over any sort of non-mandatory rules, at least. And sort of if you regulate or put too much detail into the actual arbitration agreement, you also lose a certain amount of flexibility. Something that is very common in large infrastructure projects, and the typical dispute resolution clauses I see in contracts of a day-to-day basis is multi-tiered dispute resolution clauses. So first negotiation, then maybe conciliation, mediation, and then arbitration kind of as a last resort. In principle, I think it's not a terrible idea to have multi-tiered clauses. Also, maybe to account for certain types of dispute of disputes. So let's say if it comes to the determination of a damage or interpretation of a contractual terms, then expert determination may be the most appropriate dispute resolution mechanism. If construction cannot be halted, then project accompanying adjudication may be the most appropriate, and only if there's really, the escalation is already so high that there's really nothing you can do otherwise than arbitration. So generally, it's not a bad idea. The only thing, my only pet peeve is, or what I strongly advise my clients against, is introducing a negotiation clause. So before you can let's say before you go to arbitration or any other type of dispute resolution, to have the management of both contractual parties come together and try to resolve the disputes through negotiation. Why do I think it doesn't work? Because I've seen in practice so many times that if things have escalated so far that you need to invoke the dispute resolution clause, then basically it's already too late for negotiation, and you need a third party neutral to kind of help the parties moderate their differences or to make a decision that is binding upon both parties. So yeah, that's something I always try to avoid. And another thing that is particularly important and often clients don't think about when drafting the different agreements relating to one single project is consistency with the arbitration agreements. Because if arbitration agreements are essentially, the same and compatible, arbitrations may be multiple arbitrations may be consolidated into one single proceeding, which may make sense if you have certain types of disputes arising from the same project, the same context, but involving, multiple subcontractors and multiple participants in this project. So that is another thing that, in practice can become very relevant if you want to consolidate projects. So what do typical disputes in the renewable sector look like? So it may be related to adjustments for regulatory changes or feed-in tariffs. It may relate to grid connection delays, curtailment issues. It may relate to force majeure events and hardship, delays, performance tests, liquidated damages, really, sort of the whole package. So, if you were to ask me what is it like to work in disputes in the renewal sector, it's kind of like you have to do everything all at once, all of the time. But that's also what makes it particularly interesting, in my opinion. So if we could go to the next slide. I have given you a lot of information. So let me just leave you with a few key takeaways. So to keep in mind, maybe for the future. What are the key differences? So Germany is a civil law system versus common law system. You have a highly codified interpretation versus a precedent-based system. There is a strong emphasis on good faith, at least in the renewable sector. That's something you will inevitably encounter. And just kind of to keep in mind about German law in general, it's very systematic, but it's also quite predictable through this really rigorous codification. You have a high level of flexibility if combined with arbitration. And if you understand certain, let's say, local particularities, like the limitation period, standard terms, contract adjustment, those are uniquely German levers that may sink a clause or even save a project. So I hope I've just given you some food for thought and some ideas to keep in mind just for the future. And just as a final thought, as India and Germany deepen collaboration in renewable energy, so lawyers familiar with both systems will become indispensable, and comparative contract law is no longer a purely academic concept, but it's actually a commercial advantage. So thank you very much for your attention, and I'm happy to take any questions.
Thank you so much, Dr. Rener. That was a very enlightening session for our students, and the presentation was very, very good enough. And thank you so much, ma'am. Now we move to the open floor and an interaction with our students. They have few questions, ma'am. So I request the students, one of you can please come forward if you have any question.
I'm not hearing it.
Kedar, you're not audible, dear. Can you please? You're not audible, Kedar. Just a technical thing, ma'am. Just 1 minute. We'll take.
No worries.
Ma'am, we have a question. They have sent it to
Yeah.
me. So I'll refer it on their behalf to you.
Sure.
I have a question that what are the most common contractual disputes arising in renewable energy projects under Germany law?
That's a really good question, and that's really difficult to answer because I would say like when I said literally everything all the time, all at once, I actually meant that. So it can really, because it's so manifold. It can be, from, grid connection issues. It can be, related to construction delays, design defects, any, soil conditions. It can be related to operation and maintenance, let's say, of a wind park, of a transformer platform. It's really the whole portfolio. And sometimes even I feel like my brain is about to explode, and I'm constantly learning new things. But yeah, it's very interesting. It's very fulfilling also to see, how fast this is involving, how new technologies appear, and with that, of course, new types of disputes. So that's what I say. I mean, and that's where I'm hoping for, let's say, like more opportunities to collaborate. Let's say, between a more, let's say, maybe technologically established country like Germany and India, which is the fourth largest growing market for wind energy, for example.
Yes,
So
yes, absolutely, ma'am. I agree with that thing, right? Yes, ma'am. Okay. Can I have another question, please? Any of the students? You can send me.
Am I audible now, ma'am?
Yes, you're
Oh,
audible,
yeah.
Kedar. Yes.
Ma'am, that was very insightful session, and you have covered my question. Now, will my colleague, my fellow student, will ask the question.
Good evening. Am I
Good
audible?
evening.
So, how do force majeure clauses operate in renewable energy contracts, particularly in light of regulatory changes?
That's a also very good question, and So, and that's exactly the concept I mentioned with contract adjustment. So to give you a very short and simple answer, they will usually try to account for specific scenarios. You know, let's say like, supply chain issues, weather conditions, environmental conditions, etc. And then there's always the factor of the unknown. So this is particularly relevant, and we're still working on cases like that. For instance, with delays relating to the COVID-19 pandemic. Where the question is this force majeure? Has it been sufficiently accounted for in the contract? Nobody knows really, or it's something that is highly disputed. And that is where, at least in Germany, the concept of contract adjustment comes into play. So if you imagine, okay, had the parties, if they would have been in the position to anticipate a global pandemic during the conclusion of the contract, would they have concluded the contract in exactly this manner, or would they have phrased the terms differently? So it is a fallback option, but maybe to answer again, I mean, how do they work? In disputes, not well enough, because I mean, there's inevitably going to be a dispute, and it's difficult when it comes to an unclear term.
Elucidate on how it operates.
How it operates? Well, I mean, you identify. It depends on the contractual. I mean, how it's regulated in the contract. So you have certain force majeure events that are defined in the contract that will not, let's say, considered to be a delay and not result in liquidated damages. And sort of if you have one of the items, let's say, listed as a force majeure event, let's say like, I don't know, a hurricane, then this will not be considered a delay that will trigger delay liquidated damages. But I mean, it only works if you actually have a force majeure event, or let's say it only works smoothly if you have a force majeure event that's listed in the force majeure clause. If, for instance, it's you have, and then you often have sort of a wording that says like any other type of hardship. I mean, what does that mean? That's something parties can rarely agree upon, and then you will inevitably have to have it resolved by a third-party neutral. So, yeah, does that answer your question?
Thank you.
You're welcome.
Okay, Dr. Rener, can we have one more question last for the day, please?
Sure.
Yes, students, one last question, please.
Hello, am I audible?
Yes, you're audible. Yes.
Good evening, ma'am. I have this question: that how does German contract law manages to protect the investor while also allowing enough freedom to the state to regulate energy sector?
I mean, simply by allowing for, as a general rule, for contractual freedom and freedom of form. So if there is any mandatory regulation or, let's say, form requirements, protecting investors, and that would be, for instance, like I mentioned, when it comes to contractual guarantees, when it comes to certain sort of real estate transfers, but also, let's say during the tendering and procurement phase, you have certain form requirements in the contracts, and but you also have certain transparency requirements. Let's say um, on a higher level, when it comes to the actual process of initiating such a project, during the tendering phase, and then kind of trickles down to the actual contracts. You have the tendering documents, you have the procurement contracts, and then you have the actual contracts, relating to execution. So it's all very much put in writing, and like in theory, there's no limits, but and I also try to explain the thing with contracts in this sector in German law is that if there's something that has been omitted from the actual contractual framework, if a contractual term has to be considered invalid, you always have the civil code and the clear provisions and regulations of the civil code, which you can literally read up and see all of the requirements and how it will apply. That is kind of the fallback option that will always sort of protect investors and create a certain degree of legal certainty.
Okay, ma'am. Thank you.
You're welcome.
Thank you, Dr. Rener. That was very humble of you, and that the presentation was really nice. It let us know a lot about the Germany contract law. And thank you so much, ma'am. Now we'll come to the conclusion. And for that, it's my honor to welcome and to invite Dr. Sneha Shukla, ma'am. Just a minute. Yes. And we have our Dr. Sneha Shukla, ma'am, Vice Director of Faculty of Law, GLS University, and alumni of IIM Ahmedabad, with over 2 decades of academic and institutional leadership, to deliver a formal vote of thanks. It's to you, Sneha, ma'am.
Yeah, a very good afternoon, Katia, and thanks a lot for being here. The energy transition is not only a technological shift, but a legal and institutional one. Guided by this understanding, on behalf of Faculty of Law, GLS University, it is my honor to propose vote of thanks for Day 2 of Global Juris Connect, a scholarly convergence international speaker series. I extend my sincere appreciation to Dr. Katia Rener, Associate at Clyde and Company's Global Arbitration Group, Germany, for joining us today and delivering an insightful and intellectually enriching session on renewables arbitration vis-a-vis German contract law. Her nuanced deliberations offered valuable clarity on the legal and contractual challenges arising from renewable energy projects while effectively bridging domestic contract law with international arbitration practice. The session significantly deepened our understanding of how legal frameworks are adapting to meet the evolving demands of the global energy transition. I express my heartfelt gratitude to Sri Sudhir Nanavati sir, President, GLS University, for his inspiring leadership and steadfast support. To Dr. Chandni Kapadia ma'am, Executive Director, GLS University, for her dynamic leadership and invaluable mentorship. I express my sincere appreciation to Dr. Dharmesh Shah, Provost, GLS University, to Dr. Shashank Shah, CFO, GLS University, and to all the office bearers for their support. I sincerely thank Dr. Mayuri Pandya ma'am, Dean, Faculty of Management, for nurturing and promoting such meaningful global scholarly engagement. I also acknowledge our faculty members, coordinators, and student volunteers for their tireless efforts, seamless coordination, and dedicated support, and to our students and all the participants for their enthusiastic presence, thoughtful questions, and active engagement, which added immense value and vibrancy to today's deliberations. As we move forward, we look forward to day 3 of the series tomorrow, in which Dr. Daniel Stein, lecturer at International Maritime Law Institute, Malta, will address the compelling theme of freedom from navigation in the era of geopolitical tensions. We are confident that this session will further enrich our understanding of contemporary challenges in international maritime law. I once again thank you, everyone, for making today's session a meaningful success. We look forward to your continued participation in the upcoming sessions of Global Juris Connect, a scholarly convergence international speaker series. Thank you.
Thank you, Sneha ma'am. So now we conclude day 2 of our international speaker series. We sincerely thank you, Dr. Katia Rener, and our faculty members and everyone. Wish you all a pleasant evening. Thank you, everyone. Thank you so much.
Well, thank you
Thank
very
you.
much.
Bye-bye.
And feel free
Bye-bye.
to connect or reach out if you have any questions.
Definitely,
Absolutely, ma'am.
definitely. We love to do that. Thank you so much.
Thank you. Bye.
Thank you. Thank you, ma'am.